Weiss+Associates presents Long v. Rasmussen, acknowledging the existence of legal non-taxpayers. We here at Weiss+Associates have emphasized in our material that the key to understanding the federal income tax as established by the U.S. Congress in the 16th Amendment is based primarily on understanding the impact of jurisdiction. Jurisdiction needs to be defined so that you have a reference point in this topic about the existence of both U.S. taxpayers and those who are legal non-taxpayers of the federal income tax. Please note that by the use of this term legal non-taxpayers, we are not referencing any nexus to those who are tax cheats, tax evaders, or tax protesters, as the IRS likes to use. Those expressions are only directed toward those who are legal taxpayers and choose not to file and pay their fair share of taxes determined in the Internal Revenue Code. Keep in mind that the IRC is perfectly legal and applicable, but only in a single jurisdiction. See how that word jurisdiction keeps popping up? You'll find stated in Black's Law Dictionary that the term jurisdiction means the legal right by which judges exercise their authority. It also reflects the right and power of a court to adjudicate concerning the subject matter in a given case. The term refers to areas of authority which is expressed in a geographic context in which a court has power or types of cases it has power to hear. Webster's Dictionary defines jurisdiction as the power, right, or authority to interpret and apply the law. An example might be a matter that falls within the court's jurisdiction. It also means the power or right to exercise authority or control. All of this is confined within the limits or territory within which authority may be exercised. Wow, is your head spinning yet? To keep it simple, think in terms of geography first. So, thinking in this manner helps you see something that perhaps you weren't aware of prior to this video. Let's elaborate on something that you are more familiar with, the 16th Amendment or the Income Tax Amendment. When you read the 16th Amendment, it states the following: "The Congress shall have power to lay and collect taxes on incomes, from whatever source derived, without apportionment among the several states, and without regard to any census or enumeration." Upon first reading, you may think that the 16th Amendment applies to the constitutional republic. When you do research on this, you'll even find so-called scholars who make claims that the wording used in the 16th Amendment makes it apply to the jurisdiction of the constitutional republic. These scholars are at a loss to explain how the jurisdiction issue was addressed in the wording of the 16th Amendment. When you read the amendment again, please note that there is no reference to the jurisdiction to which the amendment is stated to be applicable within. That's where the omission of jurisdiction has allowed the confusion to seep into the mind to infer that it applies within the constitutional republic, the now 50 states of the Union. These scholars simply ignore Article 1, Sections 2 and 9 in the U.S. Constitution that mandate the inclusion of the rule of apportionment for the use of a direct tax. Again, the federal income tax was determined by the U.S. Supreme Court to be a direct tax, and for it to be applicable within the constitutional republic, the rule of apportionment could not be excluded. No capitation or other direct tax shall be laid unless in proportion to the census or enumeration herein before directed to be taken. The Constitution is our protection against intrusions or attempted intrusions by the national government. The U.S. Constitution prohibits any tax being placed directly upon American nationals, as sovereigns do not tax themselves, for they are the author and source of law. See the court case Yick Wo v. Hopkins. Since jurisdiction is key to all this, there has to be two separate jurisdictions with the same names but are completely segregated from each other for the 16th Amendment to exist in the face of the Supreme Court determination in the Pollock decision. There are two jurisdictions. Surprised? The first jurisdiction is the constitutional republic that protects American nationals from intrusions created by the national government. In this jurisdiction, the 16th Amendment has no force or effect of law due to the omission of the inclusion of the rule of apportionment requirement. The other jurisdiction is the territorial jurisdiction of the national government, as stated in the Constitution to be the 10 miles square, referred to as the District of Columbia. This also includes the U.S. territories such as Guam, Puerto Rico, the U.S. Virgin Islands, American Samoa, etc. Now we need to address each jurisdiction for the identification of those who are, by the 16th Amendment, either U.S. taxpayers or legal non-taxpayers. You'll find stated in a federal appellate court decision, Long v. Rasmussen, a detailed discussion on the existence of each of these separate groups. The jurisdiction will be easy to understand once the comments are brought forward in this video. For your convenience, you can locate this important document in the resource center of our website, Weiss+Paris.com, where it's posted on the date of June 30th, 2016, and you'll find that the revenue laws promulgated in the IRC do not relate to legal non-taxpayers. On page 2 of this document, there's the statement made by a federal appellate court on this matter. The revenue laws are a code or system and regulation of tax assessment and collection. They relate to taxpayers and not to non-taxpayers. The latter are without their scope. No procedure is prescribed for non-taxpayers, and no attempt is made to annul any of their rights and remedies in due course of law. With them, Congress does not assume to deal, and they are neither of the subject nor of the object of the revenue laws. Rest assured, the federal government doesn't like to admit to the fraud that it, via the U.S. Congress, has perpetrated against American nationals for over 100 years. This appellate court, however, did show the distinction between the two separate classes of people in this case involving the IRS, as Rasmussen was today's equivalent of the IRS commissioner. Now we need to break this statement down for clarity in making the proper jurisdictional application of the 16th Amendment and the IRC statutes used by the IRS. 1. The revenue laws are a code or system and regulation of tax assessment and collection. The revenue laws referred to are those within 26 U.S.C. and 26 CFR. You know this by what's presented as well as the direct reference to the IRS procedures, assessment, and collection. The revenue laws are a byproduct of the 16th Amendment, which omitted any nexus to the rule of apportionment requirement that appears in the U.S. Constitution. Thus, these revenue laws apply only within the territorial jurisdiction of the national government, the District of Columbia. 2. They relate to taxpayers and not to non-taxpayers. The word "they" refers to the revenue laws. It's clear to see that the revenue laws only apply to one group, U.S. taxpayers. Those who are U.S. taxpayers work for the national government or are subject to the territorial jurisdiction of the national government. For more information, see the legislative intent of the 16th Amendment. 3. The latter are without their scope. The word latter refers to those who were listed second as non-taxpayers. The word scope refers to the revenue laws regarding regulation of tax assessment and collection activities authorized for use against those who are U.S. taxpayers and have not paid or filed their Form 1040 U.S. individual income tax return. One can hopefully see that the federal income tax is not directed toward those who are legal non-taxpayers. Due to the omission of the rule of apportionment, the only jurisdiction to which this group can belong is that of the constitutional republic, the 50 states of the Union. 4. No procedure is prescribed for non-taxpayers, and no attempt is made to annul any of their rights and remedies in due course of law. An example of an IRC procedure is referenced as a regulation of tax, assessment, and collection. Precise examples would be a substitute for return, assessment, deficiency, and collection actions under levy, IRC 6331A, and lien, IRC 6321. For the ease of reference, Weiss+Associates has compiled a list of IRC procedures by statute and also listed the location of enforcement regulations associated with those statutes. This is found in our resource center with a post date of March 19, 2013, List of Enforcement Regulations for 26 U.S.C. Subtitle F. What's an interesting side note is that the vast majority of the IRC statutes are supported only by regulations published in 27 CFR, which is only permitted for use by ATF, Alcohol, Tobacco, and Firearms, and not the IRS. So, no IRC procedure is listed here and can be applied to those who are legal non-taxpayers, and the IRC cannot be used to annul any rights of legal non-taxpayers. And 5, with them, Congress does not assume to deal, and they are neither of the subject nor of the object of the revenue laws. The word them refers to those who are legal non-taxpayers of the federal income tax, all due again to the omission of the constitutional requirement upon the national government to adhere to, if it desired to include the imposition of a one-time tax upon the state legislatures of the 50 states of the Union, who would, if that path were taken, then raise the funds from those American nationals living within each of the various states of the Union, and the burden would be based on the census count in order to be apportioned fairly among each state due to the population density at the time such an act would occur. Once paid, that would be the end of the tax, as it would be a one-time tax. Otherwise, Congress does not assume to deal with American nationals, legal non-taxpayers, as they are neither of the subject nor of the object of the revenue laws established in 26 U.S.C. and 26 CFR, for application only against those who are subject to and are the object of the territorial jurisdiction of the national government. All this was confirmed by former President William H. Taft in his legislative intent of the 16th Amendment, in which he admitted that the national government was deprived of any power or authority to impose a federal income tax upon American nationals. He then directed the U.S. Congress to levy the federal income tax only upon the national government itself. Jurisdiction does play a significant role, and any American national would do well to understand what the implications of this means. We also investigate how the U.S. Congress converted American nationals via fraud to be classified as U.S. resident aliens in order to levy the federal income tax against American nationals and thereby stole the wealth they created via private sector employment. This is important for you to share with your friends, private sector employers, and others who have a keen respect for the law, and not to accept the counterfeit claims that the 16th Amendment applies within the constitutional republic. You can leave the U.S. Tax Club on a permanent basis, as provided for by the U.S. Congress, by beginning the Revocation of Election process established for your option to take advantage of, so that the national government wouldn't be in violation of the 13th Amendment, which outlaws slavery and involuntary indentured financial servitude. Please visit our website, Weiss+Paris.com, and you can contact us at bilateral@gmx.com for any inquiries on how to leave the U.S. Tax Club that is completely legal, as it was established by the U.S. Congress for you to do so. We ask that you give this video a like if you found it informative and subscribe to our channel. Thanks for watching.